we had talked to Ari Berman quite a bit over the past several months about Shelby County versus Holder, which was in front of the Supreme Court, regarding Section 5 and Section 4 of the Voting Rights Act. Section 5 essentially says that there are some states that must be pre-cleared. Almost a dozen states, but really it's by county. Most of those states are southern states. However, there are counties in New York State, I believe one upstate, one that covers Queens, in California as well. Counties that have had a historical record of attempting to disenfranchise some minorities, different minorities' voting rights. And Section 5 says that those counties that are under Section 5 must be pre-cleared by the Department of Justice to make any changes to their voting laws. Section 4 is essentially the formula which determines which counties are bound by Section 5. According to the holding today out of the Supreme Court, in an opinion by Chief Justice John Roberts that was joined by, and this is going to come as a huge surprise to you, Justices Scalia, Kennedy, Thomas, and Alito, holds that Section 4 of the Voting Rights Act, which sets out this formula that is used to determine which state and local governments must comply with Section 5's pre-approval requirement, is unconstitutional and can no longer be used. So Section 5 remains, but it has virtually no effect. In fact, I think not virtually. I think it has no effect because we do not know which states are bound under Section 5. The Supreme Court basically said it has to go back to Congress and they have to develop a new formula, which I guess at that point then is presumptively constitutional until it gets back to the Supreme Court and they reject it anyways because they don't believe there's any more racism in this country. I think Justice Ginsburg in her dissent, and I've yet to read all of these rulings, said essentially this is equivalent of saying you don't need it in the same way you don't need an umbrella anymore because you're not getting wet once you carry around the umbrella. So the umbrella is no longer needed. This is going to have, I think, immediate impacts on the 2014 election cycle because you're going to see the myriad of counties and states, for that matter, who passed or attempted to pass laws that would have disenfranchised various voters, particularly Texas. That was reversed by the DOJ because it was found to be a poll tax in other clothing. You're going to see them re-implement this, and instead of the DOJ starting off by saying, no, you cannot implement this, it's going to have to then go to court. And so we're going to hear a whole new round over the next 16 months of attempts by Republican-controlled legislatures, I should say, imposing requirements to vote that will necessarily disenfranchise voters, and then the court cases that will follow.